10 gun laws just changed. This first change is the backbone of everything else. Law 1, strict scrutiny, is now the standard that's about to unfold, and it completely flips how gun laws are judged in America. For years, the government had it easy. Courts allowed restrictions to pass with little more than a vague justification, no real proof that they were necessary. But that's no longer the case. The November ruling makes it clear. Every single gun law in the country must now survive strict scrutiny, the toughest legal standard that exists. What does that mean in real terms? It means the government can't just claim a law is a good idea. They have to prove they have a truly compelling reason for limiting your rights. And not only that, they must show the law's narrowly focused and that no less restrictive option exists. The burden doesn't fall on you anymore. It falls completely on them. This one shift puts thousands of gun laws across the country at risk of being overturned. Laws that once flew under the radar or passed with emotional arguments are suddenly on the chopping block. It's a total reset, and it opens the door for real accountability. Law 2. Civil lawsuit shield for self-defense. Now, here's a change that hits even closer to home and could save you from financial disaster if the unthinkable ever happens. Let's say you're forced to use your gun to protect yourself or your family. You survive the moment only to find yourself being sued by the very person who attacked you or their family. That's not just hypothetical. A man in Ohio shot a burglar breaking into his house at 2 a.m. No criminal charges were ever filed, but the burglar's family sued and won $400,000. In another case, a woman in California defended herself from an attacker in a parking lot, only to get hit with a $1.2 million lawsuit for using excessive force. The new ruling shuts that door completely. From now on, if you use a firearm in lawful self-defense, you are shielded from civil lawsuits. Period. The attacker or anyone else can't just drag you into court. They first have to prove in a criminal setting that what you did was unlawful, and unless they can do that, no lawsuit can even begin. This changes everything. It means your home, your savings, and your future aren't up for grabs just because you protected yourself. It's one of the most powerful legal protections gun owners have ever been given, and most people don't even know it exists yet. Law 3. Police can now be held personally accountable. Here's a change that's going to make waves in law enforcement, and it directly affects how your gun rights are handled during police encounters. For decades, officers who crossed the line were shielded by something called qualified immunity. Even when they violated the law or stepped on your rights, they were protected from personal consequences. That shield is now broken, at least when it comes to the Second Amendment. This November's ruling makes it clear. If a police officer violates your clearly established gun rights, they can now be held personally responsible. No more hiding behind technicalities or blanket immunity. If they take your lawfully owned firearm without cause, they can be sued directly and pay the price themselves. This isn't just theory. It's already happening. In Virginia, a man was pulled over while carrying with a valid permit. He did everything by the book. Disclosed his firearm, followed the rules, and still the officer confiscated his gun without legal grounds. The court didn't just throw out the case. It awarded the man $300,000 in damages, personally charged to the officer. This new standard finally gives gun owners a real layer of protection against overreach. It puts power back where it belongs, and it makes officers think twice before violating your rights. Now, Law 4. The sensitive places. Loophole just got shut down. Let's talk about one of the oldest tricks in the book. Banning guns by calling every location a sensitive place. States like New York, California, and New Jersey have been using this tactic for years. They knew they couldn't outlaw carry altogether. So, instead, they created long lists of places where guns were suddenly off-limits. Parks, libraries, grocery stores. Some states had over 50 categories. You were technically allowed to carry, just nowhere that mattered. That tactic just got blown apart. The court's ruling lays down a new clear standard for what actually qualifies as a sensitive place. It's no longer about feelings or signs. It's about facts, real security. Places like carouses with metal detectors and armed guards still count. So to schools with proper screening and law enforcement on site, but a public park with nothing but a no-gun sign, that's not enough anymore. States now have to scale back their lists big time. In fact, some are being forced to cut down by 80% or more, and if you're carrying legally and walk into a business that doesn't allow firearms, they can still ask you to leave, but they can't have you arrested just for walking in with your firearm. This change restores the meaning of the law and stops states from twisting the rules to quietly ban carry rights in everyday life. It's a major win for anyone who wants their rights to mean something beyond just words on paper. Law 5. No more endless delays for carry permits. Let's be honest, just getting permission to carry legally used to feel like an obstacle course. In many states, it wasn't about denying your rights outright. It was about making the process so slow and frustrating that you gave up trying. You'd fill out all the paperwork, submit your application, and then wait and wait and wait. 3 months, 6 months, even 18 months in places like New York. No updates, no decision, just silence. That game is over. Under the new ruling, every state is now on the clock. From the moment your carry permit application is submitted, the state has 60 days to approve or deny it. And if they miss that deadline, you're automatically approved by default. They can't keep asking you for more documents unless there's a specific, clearly explained legal issue. They can't pause the clock. And if they do deny you, they have to give you a full written explanation with actual legal reasons, not just a vague rejection. The results are already showing. Some states have approved more carry permits in the last 3 weeks than they did in the past 6 months combined. The delays are done. The excuses are done. If you qualify, you get your permit on time. Law 6. You can store ammo and firearms. However you choose now, here's a change that's long overdue, because owning a gun means nothing if you can't actually use it when it counts. Some states passed storage laws that seemed reasonable on the surface, but were clearly designed to make your firearm useless in an emergency. In Massachusetts, the law said your ammo had to be locked up in a container separate from your gun. In California, it had to be stored in a completely different room. One Illinois county went even further, requiring you to store your firearm and ammunition on different floors of your home. Now, think about what that means. It's the middle of the night. You hear a break-in. You grab your gun, but it's unloaded. You run to another room, unlock a second box, load up, and pray the intruder gives you enough time to finish. It's unrealistic, it's dangerous, and now it's unconstitutional. The ruling makes it clear. Any storage law that prevents immediate access to your firearm in an emergency violates the Second Amendment. You now have the right to store your firearms and ammunition together in whatever setup makes the most sense for your home, your family, and your security. The government doesn't get to decide what's safe for you. That decision belongs to you. And now, the law backs that up. Law 7. The hidden gun registry just got exposed and ordered destroyed. For years, gun owners were told there was no national registry tracking who owns what. And by federal law, that's exactly how it's supposed to be. Since 1986, the government has been banned from creating any system that connects specific firearms to specific individuals. But behind the scenes, several states found clever workarounds. And now it's all coming to light. Take California, for example. Their dealer record of sale system quietly stored information on every handgun purchase dating back to 1996. 20 million records in total, all linking names to firearms. In Hawaii, the law required every single gun to be registered with local police, including the make, model, serial number, and owner's full personal details. The November ruling didn't just acknowledge these systems, it flat out shut them down. the court ruled that any state-run database tracking individual gun owners or their firearms is a direct violation of federal law. These registries must be dismantled within 180 days, no exceptions, and states are required to notify affected gun owners in writing that their information has been permanently deleted. Some states are already trying to push back, but the court didn't leave room for games. Non-compliance means contempt charges and daily fines until those records are gone for good. This is the first real enforcement of the registry ban we've seen in decades, and it's a major victory for privacy and gun rights alike. Law 8. No more ATF attacks over paperwork errors. This next change closes one of the most frustrating and unfair loopholes used against law-abiding gun dealers. For years, the ATF used minor technical violations, things like a wrong date, a misplaced number, or the wrong color pen as reasons to revoke federal firearms licenses. These weren't criminal acts, they were paperwork mistakes, but the penalties were devastating. One Pennsylvania gun store lost its license because the owner accidentally wrote 2022 instead of 2023 on a single form. In Texas, a dealer had his license revoked simply for using blue ink instead of black on a transfer document. These weren't threats to public safety. They were goadas used to shut down businesses the government didn't like. That ends now. The court's decision makes it clear the ATF can no longer strip someone's license over administrative errors. They must prove an actual criminal violation before revoking a federal firearms license. And if mistakes are made, the agency is now required to issue a written warning and give the dealer a fair chance to correct the issue before taking any further action. This change levels the playing field for small gun shops and home-based FFL holders. It stops the government from weaponizing red tape and using regulations as a backdoor method of gun control. For dealers who've been walking on eggshells for years, this ruling is a long overdue shift toward fairness and due process. Law 9. Concealed carry now travels with you. Having the right to protect yourself at home is one thing, but what happens when you cross state lines? For decades, gun owners have been trapped in a confusing mess of state-by-state rules on concealed carry. You could have a valid permit in Georgia, but the second you drove into Florida, it meant nothing. And unless you memorized constantly changing reciprocity maps, you were at risk of getting arrested just for crossing a border, sometimes just 20 minutes down the road. That's all changed. This November's ruling establishes a national baseline for concealed carry recognition. If your permit is valid in your home state, it's now legally recognized in at least 42 other states. No extra paperwork, no extra fees, no more legal guessing games. Your Texas permit now works in New Mexico. Your Arizona permit travels with you into most of the country. And states can't throw in extra restrictions or demand more requirements just because you're from somewhere else. If it's valid back home, it's valid on the road. Period. Police departments in states that previously refused to honor out-of-state permits are already undergoing retraining. This shift gives gun owners something they've wanted for years: the ability to travel across the country without leaving their rights behind. Of all the fears gun owners face, Law 10. You're now better protected at home than ever before. One stands out above the rest. Having to use a firearm to defend your home and then being treated like a criminal for surviving. That nightmare has played out too many times. Homeowners who clearly acted in self-defense still found themselves arrested, charged, and dragged through courtrooms for months or even years. One man faced aggravated assault charges after shooting a burglar armed with a crowbar. He had to spend 2 years proving he did the right thing. A woman in Maryland shot her abusive ex-boyfriend after he kicked in her door, violating a restraining order, and she still ended up jailed for 8 months before the case was dropped. This ruling finally brings the law in line with common sense. Now, if you use a firearm to defend yourself inside your home or on your property, the burden of proof is on the prosecution, not you. Prosecutors must prove beyond a reasonable doubt that your actions were not justified as self-defense. And unless they can do that, the case doesn't move forward. And this flips the equation. You're no longer forced to prove you were right. They have to prove you were wrong. And if they can't, you walk free. This is one of the most powerful protections ever added to castle doctrine laws. And it means that in the most terrifying moments of your life, the law will finally be on your side. These 10 changes mark the biggest shift in gun rights we've seen in decades. They affect how you own, carry, store, and defend. And knowing them could be the difference between staying protected or landing in court. Don't keep this to yourself. Share it with every gun owner you know, because these rights only protect you when you understand them. Knowledge is now your first line of defense.